Okay, now calling case number 23S00824. This is the state of Michigan versus Derek Warbach. May I have appearances for the record, please?
Attorney Ellis Friedman for the defendant, Derek Warbach.
Okay, thank you. This is the date and time scheduled for an arraignment. A complaint for a misdemeanor has been filed against you. It charges that on or about November 26, 2023, at the location of 103, that you did commit the offense of larceny by stealing a cell phone that belonged to Cynthia Barnes. The value of the property stolen was $200 or more, but less than $1,000. This is contrary to MCL 750.356. This is otherwise known as larceny. This is a misdemeanor carrying a maximum penalty of up to 1 year in jail, $2,000 or 3 times the value of the property stolen, whichever is greater, plus court costs, or both. Do you understand the charge against you?
Yes.
And do you understand the penalty?
Yes.
Then at this time, Mr. Friedman?
Well, first of all, I'd like to state that I'm not going to try the case at an arraignment, but this is probably, in 41 years of practice, the most ludicrous charge I've ever seen in my life. And I've been practicing criminal law for 41 years. He's literally charged with stealing his own phone. And it's mind-numbingly ignorant of the prosecutor's office to charge him with this offense. Secondly, the phone in question, which he pays for, was returned to Cynthia Barnes the next day after he downloaded some incriminating text messages from it. This is ridiculous, and I'm staggered by the incompetence of somebody who would file these charges, who would authorize these charges, and I'm going to deal with it accordingly. Mr. Warbach's lived in this community for basically his entire life. He has no criminal record that I'm aware of. I've represented him for, I don't know, Derek, 30 years?
30 years now, brother.
Yeah, and this is staggering. So I would ask that he be released on his personal recognizance. He's not going anywhere. He hasn't gone anywhere in 40 years. And I'm dealing with Miss Barnes' attorney on the civil matter. They have some property that needs to be divided up as they're splitting. But this is just, to say it's ridiculous is almost complimentary. So I'm sorry for the diatribe, but that's just the reality of it.
Okay. Thank you. Noted.
I haven't figured out yet how you steal your own phone. Anyway, we'll get to that. We'll cross that bridge when we get to it.
Is the Bemis Road address your home address?
Yes, ma'am.
And does Ms. Barnes currently reside there?
No, she does not.
She did.
She did, but she stays at her son's house now.
Okay. And Attorney Friedman, you can confirm this?
Yeah, it's not an issue. They no longer reside together. They did until he found the phone with the incriminating messages on it.
Okay. So based on the information the court has now and the statements from your attorney, Mr. Warbach, the court will set a PR bond with the following conditions. There's to be no use or possession of alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to commit any other crimes. There's to be no assaultive behavior against anyone, and specifically Ms. Barnes. You are not to have contact with her in the meantime. If she calls you, don't answer. Do not.
I haven't been answering.
Okay. You are not to possess any firearms, ammunition, or other dangerous weapons. If you do
None
have
in the house.
Okay. If you were to have any, they would need to be surrendered. To clarify, when I say no assaultive behavior, no making threats of any sort either. When I say no contact, I mean nothing in person, over the phone, over text message, email, through third parties, or anything.
That's fine with me, ma'am. It has been going that way since Christmas night.
So at this time, your next court date will be a pretrial conference on January 22nd, 2024 at 9 a.m. over Zoom. That will be in front of the judge. Just one moment.
That's going to be Zoom, magistrate?
Yes, that will be Zoom. Okay. Okay. So to clarify just a little bit further, you are not to go to wherever she is staying either.
I understand that. I have not been there.
Okay, thank you. So then at this point, as I said, the court is setting a PR bond. You've got your next court date is January 22nd at 9 a.m. Attorney Friedman, if there's nothing further, then the parties are free to leave.
There's nothing further today, but there's going to be a lot further. Thank you.
Thank you.
Bye, Alan. Oh,
Mr. Warbach, you can tell the jail staff that you're finished.
okay, thank you. Bye, Alice. Appreciate your help, brother.
Will you hand me my screen box?
The next case out of the jail is State of Kansas versus Jesse Taylor Greenwell, 24 CR1. Good afternoon, Mr. Greenwell.
Good afternoon.
Mr. Greenwell, you're charged by way of information on or about December 31, 2023 in Butler County, Kansas with possession of methamphetamine, a level 5 drug felony. You're charged in count 2, same date and location, possession of marijuana after a prior conviction, a class A non-person misdemeanor. Count 3, you're charged, same date and location, driving while license is suspended or canceled, a class A non-person misdemeanor. Count 4, same date and location, possession of paraphernalia for use, class B non-person misdemeanor, which the paraphernalia was plastic baggie, and 3 plastic tubes. Count 5, same date and location, expired tag or registration, and that is an unclassified non-person misdemeanor. And Mr. Greenwell, do you understand the charges pending against you?
Yes, sir, I do.
Mr. Greenwell, you do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. Mr. Greenwell, are you currently employed?
No, but I have money. I mean, I work side jobs. I do drywall.
How much money do you have set aside?
Thousands of dollars. I can't remember.
You have thousands of dollars set aside?
Yeah.
And so are you able to hire an attorney to represent you?
No, not at this time. I'm not.
Why, if you have thousands of dollars set aside, why could you not hire an attorney?
Because I don't have a way of getting to it.
What is this, cash money?
I don't know.
Really?
You don't know?
I don't know until I get out. I don't know.
Until you get out of where?
Of jail. I don't know.
Okay, you said that you had thousands of dollars set aside.
I have some money. I have some money set aside. Is what I mean. I'm not broke. Is what I'm saying.
Well, when you say you're not broke, how much money do you have set aside?
I don't know until I get out. I don't have the money. My relatives have the money.
Okay, and the money is with your relatives, and to the best of your knowledge, it's in the thousands of dollars. Is that correct? To the best of your knowledge. Okay.
Yes.
Well, based on that information, the court finds that you do have financial wherewithal to hire an attorney, so the court does not appoint counsel to represent you at this time.
Can you appoint,
Subsequently, you
can
may
you appoint
retain
me
your-
an attorney? I don't have money to pay for an attorney right now.
Well, you just said that you do, that you have money set aside to your relatives, and that's what the court understands is your situation.
Well, I don't have no way of getting to the money. I'm not going to be able to get to that money. My relatives might have money, but I don't have no money.
Okay, you're not, I need for you to not be contradictory in regards to whether you have money set aside or not. Do you have money set aside that could be used to retain an attorney?
No, I don't.
Okay, what's this money, and approximately how much is it that you have with your family, your relatives?
I don't know. This is just something that I was told.
Okay, what do you mean you were told?
I mean, I was told that I have some money coming. That's all I know.
You have some money coming, so this is not money that you gave to a relative?
No.
Okay. Well, that's a different situation what I previously understood. Subsequently, at this point in time, based with what you've said, you do not have money set aside with a relative. A relative may be willing to help assist you, but you do not have money available. Is that correct or not?
I don't know. I might.
You're fucked. You're so fucked.
Very well. The court finds, once again, you may retain whomever you wish to represent you. In the case, the court finds that, at least at this point in time, you've indicated you have the financial wherewithal to retain an attorney.
No, I
Subsequently,
don't.
the court sets your next appearance date. This would be on the felony
tell him I
preliminary
need an
hearing
attorney?
control docket. The felony preliminary hearing control docket on Monday, January 29, 2024 at 2:30. Monday, January 29, 2024 at 2:30 before Chief Judge Rickey. Monday, January 29, 2024 at 2:30 before Chief Judge Rickey. You do need to be present by Zoom
Is there a
hearing
bond? Did I
at
get a
that
bond?
time. The next item of business is to set appropriate bond in regards to yourself, Mr. Greenwell. Mr. Greenwell, what is your current address? Where you live?
602.
And is that in Augusta, Kansas?
Yes.
How long have you lived there?
For like a year?
And do you have any relatives that reside in Butler County, Kansas?
Yes.
Who would that be in relationship to you?
I have a brother, some brothers, aunts, uncles.
What are your brothers' names?
Man, why are you asking me so many questions?
I need to set a reasonable and appropriate bond for you. I need to establish the contacts that you have with the community meaning Butler County, Kansas.
I have Jake. I have Jake Billheimer, Joe Billheimer, Josh Billheimer.
And these are all half brothers, is that correct?
Yes.
Okay. And who else live in Butler County, Kansas?
That's it.
Okay. What is their address?
I don't know.
And who do you reside with, if anyone, at 602 Augusta, Butler County, Kansas?
Lucas Johnson.
And is he a roommate or a relative?
He's like both.
Okay, is he a cousin of yours? Is he another half brother?
Kind of like another half brother.
Like another half brother. Okay. Thank you, Mr. Greenwell. A recommendation for bond, Mr. Regier.
Your Honor, as I understand it, this is a defendant with some quite significant history. Perhaps most relevant, misdemeanor possession by hallucinogenic, misdemeanor possession of paraphernalia, at least one misdemeanor driving while suspended conviction, disorderly conduct, at least 2 of them, misdemeanor interference with law enforcement, as well as 3 prior felony convictions, including 1 aggravated conviction. This is also a defendant who I understand has a quite significant history of failing to appear 34 times, most recently in October of 2023. Accordingly, besides all standard conditions, including no contact with illegal drugs and GPS monitoring, the state is recommending a bond of $50,000.
Thank you, Mr. Regier. Based on the information that is presented to the court, I do believe the conditions of bond as recommended by the state are appropriate, and the court adopts the same. The court adopts
$50,000. That's $5,000. There ain't no way I'm going to be able to get out with $5,000.
just a moment, Mr. Greenwell. You need to be quiet until I finish with going over the order of the court. The court does adopt the GPS monitoring and all other conditions of the bond that have been. And Mr. Greenwell, can you take your hair and pull it back so I can see? Yes, so I can see you. Thank you. So the court adopts all the conditions of the bond. In regards to the amount of the bond, it appears to me that you have established with the court, you have local residents, you do have contact with the community, and I do believe that there is necessary a cash or surety bond. Mr. Regier, once again, did you say that there are failures to appear of 34 times, or did I misunderstand?
That is my understanding, Your Honor, most recently in October of last year.
Okay, based on the statements to the court, Mr. Greenwell, of you failing to appear 34 times, which appears to be an excessive amount, and Mr. Regier has advised the court as an officer of the court does adopt the recommended $50,000 cash or surety, $50,000 cash or surety bond. I think that will be sufficient to have a bail bondsman make sure that you're appearing before the court as ordered by the court. Once again, your next appearance date is before Chief Judge Rickey. That would be on the felony preliminary hearing control docket Monday, January 29, 2024 at 2:30. There being nothing further to come before the court is in recess. Mr. Greenwell, have a good day.
Is there any way you can talk to somebody about that?
All right, Mr. Martin, good morning, sir. Ms. Manarino, good morning.
Good morning, Your Honor.
All righty. This is case 231510OT. And today, date and time set for a settlement conference. Parties have an opportunity to discuss the matter.
Good morning, Your Honor. Angela Manning on behalf of the people. Your Honor, I did have an opportunity to hear Mr. Martin's position on the issue while we were in the breakout room. He requested that I dismiss the case. The people are unwilling to do so and would ask the court set this for a trial.
We've already had the motion to dismiss. And this is the motion on the demand for the body cam footage. Is that correct, Mr. Martin?
Yeah, that's one of the things I recently filed among some others. Yeah, go ahead.
All right, so this is there body cam footage, Ms. Manarino?
Your Honor, I believe there is, and if the court wants to enter a discovery order in this matter, I think that would allow Mr. Martin to have access to the video that he's taken.
Alrighty, so let me just make sure that there's. All right, so I will enter the order for discovery. And then Mr. Martin, you can request that from the, once you get a copy of the order, you can request that from the PD. Now, as far as the moving forward goes, because obviously Mr. Martin's going to need to watch the video to further whatever prepare for his case. So are we setting this for a jury trial, bench trial, or a settlement conference?
Not clear about what you said about the discovery. You just said something about I can get it from the PD after an order, so I'm not clear on what you're saying.
I can't tell you how to practice law, sir. So I can't tell you how to go about that. I'm going to enter an order for discovery.
All right.
And then you take your steps to get the discovery. All right. So
the orders I'd be given to it. If you're just going to tell me I can go to the records office and get it, that's not providing me with the information.
I'm not telling you how to do it, sir. I'm just telling you I'm entering an order whereby you'll be able to get the gather information that you need to for your case. So.
All right, we'll just see when it comes in. But like I said, you're just not being totally clear on what's that going to be or whatever. But so I can't possibly object to it now. If anything, I have to wait and see what your written order says. But okay. So.
Right. So we're going to set this up for, are we setting this for a bench trial, a jury trial?
Does need to. Well, first I'll object to, I don't think I can get a jury trial as one by one's peers, and I don't think that's going to be able to be attained because I doubt if I can find a jury of my peers, which would be those that who acknowledge as one of the people, sovereign people. Mostly everyone's probably, if not every jury member would say.
That's not how it works, but I'm just telling you, it's not how it works. You have to get back on Google and Google whatever other story you want to come up with. Peers just means anybody who's over the age of 18 who lives here in the city of Taylor. That's your peers who are also registered voters. That's where the jury pool comes from. That's what the Constitution allows for. They don't have to be, when you say like-minded, that doesn't mean that they have to subscribe to some archaic form of the Constitution that isn't how it actually reads. And I'm a pure constitutionalist myself, so I get that. But that's not what that's absolutely not what it means. Not to mention, I can't tell people, I can't exclude people from a jury pool because they have a constitutional right to serve on the jury. And that would actually be violating their constitutional rights if I asked them whether or not they subscribe to some sort of sovereign citizen theory of the Constitution and then exclude them because of their beliefs. That's literally unconstitutional to do that. So what you're asking me to do is something unconstitutional. You will have a constitutional jury of your peers, as it has been declared by the United States Supreme Court of how that works. So are you requesting a jury trial or a bench trial? That's the simple question.
If I request a jury trial, would it be fraudulently presumed that I'm giving jurisdiction?
Say again?
If I say I want a jury trial, is that going to be fraudulently assumed by you that you have jurisdiction over me?
Don't make me grate your ass.
First off, I already established that I have jurisdiction over you. You committed a crime in the city of Taylor. I have jurisdiction over you. The court does. So we already discussed that part. You can order the transcripts from that first time when we already went through jurisdiction. If you didn't understand it from there, you can always order the transcripts and reread it. But clearly, I already have jurisdiction. So, and I don't fraudulently assume anything. Everything I do is done because I was elected to be the judge here. I am sworn in as the judge here. I uphold the Constitution. Matter of fact, I keep a copy of my oath right here on the bench. Why? Because it means a lot to me. So there's nothing fraudulent about anything that I do, sir. I will tell you this: you will get you will get a fair trial. That's for sure. That's why, because that's what the Constitution requires for everybody to get. And so if you're implying anything other than that, that's not going to happen. So again, jury trial or bench trial, I need to set it for one or the other, sir.
I object to the truth that you're asserting. I don't agree that that's true what you said there. But
Sure.
if it's going to force the hand, like I said, it's going to be a jury.
All right, so jury trial it is.
But I'm
So I'll set that. Go ahead.
It's only through fraud and duress do I say that. But that's all I'm under here. Fraud and duress.
This is like explaining gravity to a chicken.
Okay. Well, first off, there's nobody, there is no fraud nor duress. You're sitting in your own home. You're on Zoom. There's nobody twisting your arm. No one's holding any weapon to you in order to necessitate a duress type of thing. And basically, I gave you a choice. Do you want a bench trial or a jury trial? So it was up to you to pick, and you wanted a jury trial. There's nothing wrong with that. You have a constitutional right to set jury trial, and we'll make that happen. So, again, nothing but due process and fairness happening here. So we're going to set this for a jury trial, and you'll be receiving notice in the mail when that will be.
Thank you, Your
I'll
Honor.
also be mailing out a copy of the scheduling order. Have a good day, sir.
I would say,
Happy
Thank
Happy
you.
New Year's.
notice is talk. You don't give a person a respond, and then you say how something ain't threatened arrest, but you don't.
But you know, when I make a ruling on something, a ruling is literally, there's no response to it. That's what the ruling is. So the ruling is, I'm going to set it for jury trial. Your motion for discovery is granted. I'm going to send out an order for the discovery. And there's really no other response needed other than Happy New Year. You'll get your date in the mail for the jury trial, and you'll get a copy of the order in the mail.
You know, that's clearly obvious. Fair to say there's no response. That's saying what I say is that, and that's it. There's nothing to say about it. Obviously, you don't believe in the Constitution too much because you're not giving me my due process right to say what I have to say. Meaning,
Well, first off, listen. If you're just gonna needlessly jabber about things that have nothing to do with anything of the case, you've already won your motion. So I'm not really sure what more you need to make a record on. I literally said, hey, we're going to enter an order for discovery. You requested discovery by a motion, and I'm granting discovery. So there's really no more record to be made other than if you want to say something like, yay, I won, or something like that. But there's nothing more to add to that. If it's about the facts of the case, this is not the time or the place to talk about the facts of the case. That's what the whole point of a trial is for. And then you can prove your case to, you don't have to prove anything. The prosecution has to prove their case. You can present things or you can remain silent. You have the right to do that. You can be a witness for yourself. You can do that if you choose. So with regard to that, that's how we're going to proceed. And then, so we're going to send out again the jury trial notice in the mail, and you'll receive it at that point. In the meantime, stay safe, have a blessed day, and a Happy New Year, sir.
Well, I'm not done yet.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in court. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No, I know.
Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that sees the drink.